I'm going to talk to you about the role of the advocate and how advocacy support can be a benefit to carers. I'm going to start off by chatting to you about what advocacy means. In very general terms, I'm going to give you a simple overview. An advocate is someone whose job it is to help a person to have a voice. An advocate will help you to speak out and tell other people what you want. They will help you to consider your options, and they will talk to you about the implications of making any decision. An advocate will listen to you and make sure other people understand your views, your wishes and your feelings. An advocate will always be led by the needs of their advocacy partner, and we will give you as much or as little support as you feel necessary. Some people simply want an advocate to sit by their side in a meeting, whereas other people might want the advocate to speak on their behalf. Advocacy is about supporting a person to be as empowered as they can. Advocates are not part of social services or the NHS. We're completely independent. We will never give advice. We will never tell you what you should or shouldn't do. We'll never judge you or tell you that we disagree with you, because we would never presume to know what you want as well as you do. Our role is to present your views as if they were our own. In England and Wales, there are certain circumstances when a person has the right to receive support from an advocate. The law says that in some circumstances this should be offered and must be granted if you ask for it. You're never under any obligation to receive support from an advocate if you really don't want to, but it's something that you should know is available if it is something that you feel would help you. I'm not going to go into huge detail about the legal side of this because it's extremely complicated and really quite boring. What I'm going to do is I'm going to concentrate on how advocacy can be of benefit to carers. The first area I'd like to discuss is the right of the carer to receive advocacy support under the Care Act with regard to carers' assessments. Now, for those of you who don't know, the Care Act is a law that lays out in a standard form how a person with care and support needs is assessed and how their care needs are planned and delivered in a way that meets the needs that are best for them. The Care Act also states that anyone who looks after a person with care and support needs has a right to receive an assessment in their own right. The purpose of a carer's assessment is to allow the carer to meet with the social worker or health professional or social care assessor to look at what help and support is available to support them, to find out what support they might need and to help them to make a decision about the future. Any carer has the right to be supported by an advocate at this assessment if they have substantial difficulty in understanding the assessment process and they have no one available who is appropriate to support them to understand this. The advocate will meet with you before the assessment to find out what you may want to say, to discuss the outcomes you wish to achieve from the assessments, and to make sure that they understand what you want. They will listen to you and they will talk to you about what options you have. An advocate will find out from you how much support you wish them to provide to help them get your point of view across during the assessment. And the advocate will support you when you meet with care providers to complete the assessment process. An example of this is Jim and Linda. They both have a learning disability and Linda has quite complex physical health needs. Jim and Linda are both unable to read and write and have difficulty with processing information. They got married 5 years ago when Jim was 58 and Linda was 40. Jim has always been the primary carer for Linda, doing most of the housework, the cooking, the budgeting, the shopping. Recently, Jim has experienced a decline in his own physical health and has become confused. Jim puts this down to stress because he feels that Linda's care needs have increased. and he reports that he never has time for himself now and has stopped going out to his local club. He doesn't have any contact with his friends and he's feeling very isolated, very lonely. A combined assessment was undertaken for Linda's care needs and to identify appropriate support for Jim as her carer. A care package was put in place to support Linda with her personal care, with accessing the local community by going to a craft club for 2 hours a week, and a morning care call was put in place to prompt with medication and helping her to get dressed. A sitting call was also put in place for 2 hours to enable John to visit his local social club and reconnect with his friends to have a break from his caring responsibilities. Both Jim and Linda report that they're much happier now, and the present arrangement of Jim being Linda's primary carer is no longer at risk of breaking down because Jim now feels that he's got support and time to address his own social needs. The second type of advocacy, of statutory advocacy, I'd like to tell you about is for people who have rights under the Mental Capacity Act. A person is eligible to receive support from an independent mental capacity advocate or an IMCA if they, first of all, don't have capacity to make a decision about either serious medical treatment or change of accommodation. They can receive support if a review of care is taking place or safeguarding concerns have been raised with protective measures. They don't have to be referred under those circumstances, but they can. And secondly, the person must have no friends or family with whom the decision maker can consult. If you are the carer for a person who doesn't have capacity to make important decisions about the future living arrangements or medical matters, then the person who is responsible for making these decisions must consult with you. The Mental Capacity Act is really clear about that. You have to be consulted. They have to listen to your thoughts and feelings about what your friend or family member would have wanted if they still had mental capacity around this decision. They may disagree with you, they may override your wishes, but they must be able to demonstrate that their decision is based on the 5 principles of the Mental Capacity Act, and these are: first of all, it must be established that the person about whom the decision is being made doesn't have capacity to make the decision, and this should be done by documenting a mental capacity assessment. Secondly, it must be assumed that the person can make a decision and all practical steps are taken to support them to do so. Thirdly, it must never be assumed that just because someone chooses to make an unwise decision, that they don't have mental capacity. Fourthly, any decision made must always be in the best interests of the incapacitated person. And fifthly, any decision must always be the least restrictive option. It's important to mention that being consultable under the Mental Capacity Act doesn't relate to whether you're a blood relative of the person who lacks capacity. If you care for a friend, if you know them well and you understand their wishes, then you should be consulted. An example of this is Bill, who was a 96-year-old man who recently lost his wife of almost 70 years. Bill went into hospital following a fall at home. He lay undiscovered on his bathroom floor for 15 hours before he was able to raise the alarm. When he arrived at hospital, he was cold, he was distressed, and he was in pain. He spent several weeks in hospital, and it was decided that Bill did not have capacity because he wouldn't comply with the diabetic diet. It was also recorded that he'd been aggressive towards staff. An IMCA was instructed and visited with Bill on the ward. The IMCA explained to Bill why they'd come to visit him and spent the afternoon engaged in conversation, learning much about Bill's life and the circumstances that led to him being brought into hospital. Bill explained that he was upset with the staff because he'd repeatedly asked them to contact his friends to let them know where he was, but no one had done so and no one had been to see him. He was also angry when staff came to perform personal care and didn't introduce themselves or tell him what they were going to do. Bill freely admitted that he'd not been an easy patient to nurse. The IMCA was able to make contact with Bill's friends and sought their views on Bill's situation and his ability to make decisions for himself. His friends were very happy to be involved in supporting Bill to make his own decisions once the IMCA had explained that they didn't actually need to make the decisions for Bill, but simply to help him think about what he wanted. Bill had made it very clear that he wanted to return to his bungalow where he'd spent many years living with his wife. He was happy to accept care in his own home, and his friends felt that he would manage very well with support from carers and from them. The IMCA wrote a report asking the decision maker to consult with Bill's friends and to assess his capacity in relation to the decision to transfer him to long-term residential care. When the IMCA returned to see Bill 2 days later, the IMCA was informed that Bill had been moved to an EMI unit of a large local nursing home. Bill's friends had not been told that he'd been moved or where he was now. The IMCA visited Bill at the EMI unit and asked his permission to tell his friends where he was. Bill readily agreed to this. He was sitting alone in the room with the curtains closed when the IMCA visited. He had a blanket on his head and staff reported that he'd refused to engage from the time he'd entered the home. The IMCA sat with Bill and reminded him that they'd met at the hospital. Bill recalled the meeting and told the advocate that he couldn't believe, after many years as a public servant and having a distinguished military career during the Second World War, he'd been left in there to die. The IMCA supported Bill to meet with a specialist solicitor who took Bill's case to the Court of Protection. The court found that Bill had been unlawfully discharged and unlawfully detained under the deprivation of liberty safeguards, as he did have mental capacity. With input from his friends, Bill is now back at home in the bungalow that he loves. He has 4 care calls a day, and his friends visit him to take him to the golf club twice a week, where he enjoys a meal, a pint of bitter, and the company of his oldest and dearest friends. I'll move on now to talk about advocacy support under the deprivation of liberty safeguards for carers. Deprivation of liberty safeguards apply to anyone who's been assessed as lacking capacity and are in a situation in a care home, a nursing home, hospital or a similar placement where they are under continual supervision and would be prevented from leaving if they attempted to do so. They might never attempt to do so, they might not even be able to do so, but if they tried, they would be stopped. A DOLS must be put in place by the local authority, and this should contain conditions which must be adhered to. Examples of such conditions might include putting arrangements in place so that somebody can have regular contact with the family or with the friends. Or it might mean putting things in place so that they're able to practice their faith. Anyone who is subject to a DOLS has the right to a relevant person's representative or an RPR. If the incapacitated person has an appropriate person to support them with the DOLS, this person is called an unpaid representative, and they have the right to advocacy support from an advocate under 39D of the Mental Capacity Act Deprivation of Liberty Safeguards. If the person asks the supervisory body for the support of a 39D IMCA, their representative asks the supervisory body for the support of a 39D IMCA, and the supervisory body believes that the person or their representatives would benefit from the support of a 39D IMCA. The reasons for the 39D instruction are broken down into separate items. The last 3 items that are covered, and the supervisory body can also instruct a 39D IMCA if, without the help of such support, the person would be unable or unlikely to apply to the Court of Protection to request a review, or if they've already failed to do so when it would have been reasonable for them to. A 39D IMCA will not stay involved in a person's deprivation of liberty safeguards standard authorisation indefinitely. They'll usually close a case if the person or their representatives understands the authorisation as well as the rights to access reviews, court of protection and 39D IMCAs. They will stay involved if the person or their representative needs support while accessing the rights to a review or to access the court of protection. The final advocacy support which affects carers is the Independent Health Complaints Advocacy Service, or ICAS. Anyone can make a complaint through the formal NHS complaints procedure for a person if they have signed consent to do so. The episode of care which is of concern must have occurred within the previous 12 months, and it must be about NHS care and treatment. An ICAS advocate will always ensure that a consent form is signed by the complainant, but if the person has difficulty communicating or signing, the advocate won't have any problem accepting verbal or visual consent and document this in the notes along with reasons. The NHS complaints process can ask for 3 possible outcomes. The first is an explanation of why care and treatment went wrong. The second is an apology if the care provider admits that things went wrong, and the third is a change in process so that the same thing doesn't happen again. An ICAS advocate will support people to make their complaint by writing a letter. They will support at local resolution meetings, and they'll help people to prepare for meetings. They'll discuss what questions to ask and will help people to go through responses. An ICAS advocate will advise on the process and procedures, but we will never tell you whether we think that you've got a good complaint or whether we think that your complaint is valid or worthwhile. It's your complaint, and we're only concerned to help you to have a voice in the process. ICAS advocates can support people to take their complaints to the Parliamentary and Health Services Ombudsman, and we can advise on whether they are likely to accept your complaint or not. We cannot support with taking legal action when medical matters go wrong. An example of this is Misha, a 74-year-old lady who's married to John. English is not Misha's first language, and while she speaks fluently, she struggles to get a point across and often becomes frustrated when people appear to misunderstand her. John has a significant number of very serious health problems, including liver failure, kidney failure, terminal prostate cancer and advanced Parkinson's disease. John spent several months in a specialist liver unit, and Misha feels that his care when he was there was absolutely exemplary. When he was discharged home to be cared for palliatively, he suffered a relapse and was readmitted to another hospital. Misha contacted the ICAS team as she had already made a complaint and felt that she needed support at a local resolution meeting with the Trust. The advocate met with both Misha and John before the meeting and obtained John's verbal consent to support with the complaint. John was too poorly to attend the meeting. Misha was supported to tell the Trust how upset both her and John were when he was left without pyjama bottoms, pants or continence pads on the ward, that night staff had shouted at John for asking for the toilet, and that John had been unable to feed himself because of his tremors, and Misha had been told that she wasn't allowed to stay on the ward to help at meal times. The matron for the hospital and the senior ward sister thanked Misha for bringing these matters to their attention and said that a complaint had prompted further investigation and had highlighted significant problems on the ward. The leadership team on the ward had been replaced and a regime of staff training had been undertaken, with some staff being replaced. Changes had also been made to the way patients' notes were recorded and other documentation. Misha and John received an apology, and significant changes were implemented to make sure that these mistakes were not repeated. I hope I've been able to provide some useful information on how statutory advocacy can help support and inform carers. We're always on the end of the phone. If anyone who's watching this thinks we can help them, please give us a call. Even if we aren't commissioned to support you directly, we'll always try to point you in the direction of somebody who can.